The sound wasn't just loud, it was violent. Chainsaws screamed as century-old trees collapsed one by one, crashing into the dirt like they meant nothing. Dust filled the air. Birds scattered. And standing there with their arms crossed, watching it all happen, were the HOA board members. I ran toward them yelling, "That's private property." The HOA president didn't even look at the papers in my hand. She just pointed at the woods and said, "This land belongs to our community farm now." Now. Those woods were mine long before the HOA existed. Before their bylaws. Before their signs. Before their so-called community plans. But in one afternoon, they decided none of that mattered. Bulldozers rolled in without warning. No court order. No agreement. No permission. Just raw power and entitlement. When I threatened legal action, they laughed. One of them actually said, "Trees don't have deeds." They thought once the woods were gone, the fight was over. They thought I'd be too broke, too tired, too alone to challenge them. What they didn't know was that every tree they destroyed was evidence. Every lie they told was documented. And every inch they stole would cost them far more than land. They destroyed my woods to expand a farm. So I took something from them they never expected to lose: control. Before we continue, drop your city or state in the comments so we can see how far this story reaches. And if you believe in justice over intimidation, like this video and subscribe. This channel stands for accountability. I bought that land years before the HOA ever existed. Back then, it was just quiet roads, open sky, and a stretch of woods that wrapped around my property like a natural fence. Those trees weren't decoration. They marked the boundary. They held memories. Family walks. Long afternoons. A sense of peace you don't get back once it's gone. When the housing development arrived, I didn't fight it. New neighbors moved in. An HOA formed. Signs went up. Rules followed. I kept my distance and my paperwork. My deed was clear. My property survey was filed with the county long before their bylaws were even drafted. At first, the HOA meetings didn't concern me. Then the flyers started appearing: community farm expansion. They showed diagrams with green shading that crept dangerously close to my tree line. I questioned it once, politely. I was told it was just a concept. Then came the letters. HOA notices claiming shared land, easements, and community use zones. None of it matched my records. I sent copies of my survey. I asked for clarification. No response. A week later, orange markings appeared on my trees. I called the HOA office. Voicemail. I emailed. Automated replies. The next morning, heavy equipment showed up at the edge of my woods like it had every right to be there. That's when I realized this wasn't a misunderstanding. It wasn't poor communication. It was a decision. And they had already decided that my land was easier to take than to ask for. By the time I reached the tree line, the machines were already moving. A bulldozer idled like it was waiting for permission it never needed. Men in hard hats avoided eye contact. Orange paint slashed across trunks I had known my entire life. The HOA president stood there with a clipboard, smiling like this was a ribbon-cutting ceremony. I told them to stop. Loud. Clear. Repeated. She didn't flinch. She said the words slowly, like she'd practiced them: "This land falls under a community agricultural easement." I asked her to show me the document. She waved a packet of papers from 10 feet away, never letting me touch them. I told her I had my deed, my survey, my county records, and my truck. She shook her head and said, "Our attorneys already reviewed this." That's when the first tree fell. The sound hit my chest. A deep crack, then a heavy thud that rattled the ground. It felt deliberate. Like they wanted me to hear it. Like every falling tree was a warning. Neighbors started gathering. Some filmed. Others whispered. A few looked uncomfortable, but nobody stepped in. The HOA president raised her voice so everyone could hear. This is approved work. Anyone interfering will be reported. I called the police. When the officer arrived, the HOA swarmed him with documents. Bylaws. Maps. Highlighted sections. The president spoke fast and confident, using words like authorized, common good, shared resource. I stood there waiting my turn, holding my original deed like it was suddenly invisible. The officer sighed and said the words I dreaded. This looks like a civil matter. And just like that, the machines kept going. Trees fell all afternoon. Wildlife ran. Stumps stacked up like trophies. By sunset, a wide scar cut through my land, exposing soil that hadn't seen daylight in decades. The HOA didn't stop. They brought in fencing the next morning. Then signs, future community farm. When I protested again, they escalated. I received violation notices for interfering with authorized HOA projects. Fines. Threats. One letter warned that continued resistance could result in legal action against me. Another suggested I was misinformed about my own property. At the next HOA meeting, they spoke about me without naming me. Certain landowners. Uncooperative parties. Applause followed. I sat in the back and listened as they justified theft with smiles. Then the farm equipment arrived. Raised beds. Irrigation lines. Storage sheds. They built right over the space where my woods used to stand. Every time I drove past, it felt like a dare. I consulted lawyers. Some said it would be expensive. Others said HOAs were difficult. One told me, flat out, they usually win. The HOA knew it too. Their attorney sent a letter stating that any lawsuit would be vigorously defended. They claimed decades-old easements. Environmental permissions I'd never heard of. They even implied the land had always been intended for shared use. But something didn't sit right. The dates didn't line up. The maps didn't match my survey. And the more confident they sounded, the more careless they became. They repeated the same claims everywhere, in emails, in meetings, and court filings, without changing a word. That's when I stopped reacting and started documenting. I photographed everything. Filmed every meeting. Requested records. Filed public information requests with the county. I stopped arguing and started listening. Every lie. Every contradiction. Every overconfident statement went into a folder. They thought the destruction was the end of the story. They thought once the trees were gone, the proof was gone too. What they didn't realize was this. They hadn't erased the evidence. They had created it. And while they were busy planting crops on stolen land, I was planting something far more dangerous, a case they couldn't outrun. Once the lawsuit was filed, the tone changed, but not the arrogance. The HOA's attorneys responded fast, thick packets of legal language designed to intimidate more than explain. They denied everything. Claimed long-standing rights. Accused me of misunderstanding my own boundaries. In one filing, they suggested the woods had been historically treated as common land, as if repetition could rewrite reality. I sat across from my lawyer, watching him flip through their claims. He didn't panic, but he didn't smile either. "They're betting you run out of money," he said. "Or patience." Both were running thin. Legal bills stacked up. Time off work became unavoidable. Friends started asking why I was still fighting. Some neighbors stopped waving. Others avoided eye contact completely. The HOA made sure the narrative spread before the truth could catch up. At community meetings, they framed the lawsuit as an attack on the neighborhood. One person trying to stop progress. They said the farm fed families. Supported sustainability. Anyone who questioned them was labeled selfish. I became a name spoken with irritation, not facts. Meanwhile, the farm kept expanding. They installed permanent fencing, thick, locked, unmistakably final. They poured gravel paths. set up signage explaining the community vision. It felt intentional, like they were building over my claim to make it harder to undo. My attorney filed motions for an injunction. The HOA fought them aggressively. Their filings were polished, confident, overflowing with maps that almost matched mine, but not quite. The judge reviewed everything and delayed a ruling, ordering further discovery. That delay nearly broke me. Discovery dragged on for months. Every request for records was met with resistance. Lost emails. Redacted minutes. Surveys without signatures. My lawyer noticed patterns, entire years missing from HOA documentation. When we pushed harder, the responses became hostile. The HOA's legal team started playing games. They scheduled depositions at inconvenient times. Objected endlessly. Filed motions accusing me of harassment for requesting documents. One motion even suggested my evidence was emotionally motivated rather than factual. But facts have a way of surfacing when pressure is applied. A breakthrough came from an offhand comment in a deposition. An HOA board member mentioned using old county maps to justify the farm boundary. Not surveys. Not deeds. Maps. That detail stuck. We requested those maps. The HOA delayed. Claimed they were proprietary. The judge ordered them released. When they finally arrived, my lawyer went quiet. They weren't what the HOA had been describing. The maps were outdated, decades old. Drawn before the land was subdivided. Before my deed existed. They showed broad, undefined areas marked as undeveloped. Not community land. Not shared space. Just blank. The HOA had been treating blank as theirs. Worse, they'd been submitting those same maps to justify funding. Grants. Agricultural incentives. Public support. All based on boundaries that didn't legally exist. We dug deeper. County records told a different story. My survey was filed, stamped, and cross-referenced with tax parcels. The woods were clearly inside my property lines. The HOA had never applied for rezoning. Never received environmental clearance for tree removal. Never disclosed the dispute when seeking farm support. Every claim they made unraveled under scrutiny. Still, in court, they acted unbothered. Their attorney spoke confidently, painting me as emotional, resistant to community growth. He described the farm as a benefit, the trees as expendable. At one point, he even said, no one can prove those trees were legally significant. I felt the room shift. The judge leaned back, hands folded, listening carefully. He asked a few questions of calm, precise. Requested specific documents. Ordered additional review of environmental compliance. That order changed everything. Suddenly, the HOA wanted to talk settlement. Quietly. Informally. They suggested compromise. Partial land use. Shared management. It was the first time they acknowledged uncertainty. I said no. Not because I wanted revenge, but because the truth hadn't been fully exposed yet. And something told me the deeper we went, the worse it would get for them. The pressure mounted. Environmental agencies requested information. Grant administrators asked for clarification. The HOA board stopped smiling at meetings. Lawyers whispered constantly. Filings grew defensive instead of confident. And then, buried in a routine county response, we found it. A reference number tied to a protected land designation. My woods weren't just private property. They were protected. The realization hit like a loaded silence. The kind that changes how everyone breathes in the room. My lawyer closed the file slowly and looked at me. They didn't just trespass, he said. They crossed a line they can't undo. Up to that moment, the conflict had been about land. Now it was about consequences. And the HOA had no idea what was about to surface next. The protected land designation didn't announce itself with flashing lights or dramatic headlines. It was buried in a county response packet, a single reference number tucked into the margin of a zoning document most people would never read twice. But once we saw it, we couldn't unsee it. My lawyer requested the full file. What came back changed everything. Decades earlier, long before the HOA, the woods had been documented as part of an environmental buffer zone. Not a park. Not public land. Privately owned, but protected. The designation limited clearing, required special permits, and mandated environmental review before any development. The HOA had none of that. No permits. No assessments. No approvals. They hadn't just cut trees, they had violated environmental law, zoning law, and grant compliance rules all at once. The reason it hadn't surfaced sooner was simple: nobody had ever tried to bulldoze it before. We prepared the evidence quietly. Updated surveys layered over county maps. Environmental statutes highlighted and cross-referenced. Emails from the HOA proudly stating they fast-tracked the farm project. Grant applications describing land they didn't own as community-controlled agricultural space. The more we assembled, the clearer the pattern became. They didn't misunderstand the land. They rebranded it. The court date arrived. The HOA entered confident, dressed sharp, carrying the same binders they'd used since day one. Their president sat in the front row, chin high, whispering to her attorney. They expected another procedural hearing. Another delay. Another chance to outlast me. Instead, my lawyer asked for permission to present supplemental evidence. The judge agreed. We started with the basics: my deed, my survey, the tree removal dates. Then we moved to the county zoning file. The reference number appeared on the screen. The judge leaned forward. "What is this designation?" he asked. The HOA attorney froze, just for a second. He attempted to explain it away as obsolete. My lawyer countered with the statute still in effect. Then came the environmental compliance requirements. Then the absence of permits. Then the timeline showing clearing happened before any review. The room shifted. The judge asked the HOA directly if they had environmental clearance. They did not. Then came the grants. We presented copies of funding applications. The land descriptions. The acreage numbers, numbers that only worked if my woods were included. The HOA president's signature was at the bottom of every page. The judge read in silence. When he looked up, he asked one question that cut through everything. "How did you claim land you did not own?" No one answered. The HOA attorney attempted to redirect. Suggested community benefit. Implied technical misunderstandings. The judge stopped him mid-sentence. This court does not recognize benefit derived from unlawful conduct. That's when the color drained from the HOA president's face. The judge ordered a recess. When court resumed, the tone was different. Sharper. Focused. Environmental agencies were formally notified. Grant administrators were referenced by name. Potential fraud was no longer implied, it was stated. The HOA tried to settle again. Urgently this time. Their attorney leaned toward us, voice low, promising resolution. I didn't respond. Because the truth was finally standing on its own. The judge ruled that the HOA had acted outside its authority, misrepresented land ownership, and failed to comply with mandatory environmental protections. He ordered an immediate halt to farm operations on the disputed land. But he wasn't done. He scheduled a separate hearing for damages, environmental restoration, and potential referral to oversight agencies. The courtroom was silent. For the first time since the trees fell, the HOA wasn't in control of the narrative. Their confidence collapsed into paperwork and whispers. The farm they built as a symbol of power now sat frozen under court order. As we packed our files, the HOA president avoided my eyes. Outside the courthouse, reporters waited. Neighbors gathered. Questions flew. All I said was this. They thought destruction erased ownership. It only revealed it. The twist wasn't just that the land was protected. It was that every step the HOA took to hide their overreach had made the consequences unavoidable. They didn't just lose ground. They exposed themselves. And the fallout hadn't even begun yet. The final hearing didn't feel like a battle. It felt like a reckoning. By the time we returned to court, the atmosphere had shifted completely. The HOA arrived quieter. Smaller somehow. Their legal team was still present, but the confidence that once filled the room had evaporated. No bold claims. No dramatic gestures. Just folders, whispers, and nervous glances toward the bench. The judge opened with a summary that was calm, precise, devastating. He recounted the unauthorized tree removal, the misrepresentation of property boundaries, the absence of environmental permits, the misuse of grant funds. Each point was delivered without emotion, which somehow made it worse. This wasn't anger. This was clarity. When the HOA attorney attempted to interrupt, the judge raised a hand. "You've had ample opportunity to explain." He turned to the environmental findings. Independent experts confirmed that protected vegetation had been destroyed without review. Soil erosion risks had increased. Wildlife habitats had been displaced. Restoration wouldn't be symbolic, it would be mandatory, monitored, and expensive. Then came the question of intent. The judge referenced internal HOA emails we'd submitted. Messages discussing how to move fast before objections slow things down. Another advising that including my land would simplify the grant process. The words hung in the air, stripped of the confidence they were written with. Intent was no longer in question. The HOA president was invited to speak. She stood slowly, hands shaking despite her attempt to stay composed. She spoke about community vision, about good intentions, about misunderstandings. The judge listened, then responded with a sentence that ended everything. Good intentions do not excuse unlawful actions. The ruling followed. The HOA was found liable for trespass, environmental violations, and fraudulent misrepresentation. They were ordered to pay damages for the destruction of my woods, including loss of use, restoration costs, and legal fees. The farm was shut down. Permanently. The court ordered all structures removed from the disputed land. Soil remediation supervised by environmental agencies. Native trees replanted under a multi-year monitoring plan at the HOA's expense. Then came the part no one expected. The judge referred the grant filings to state oversight bodies for investigation. He explicitly stated that the court found probable cause to believe public funds were obtained under false pretenses. The room reacted before anyone could stop it. Gasps. Murmurs. A reporter dropped a pen. The HOA president sat down hard, staring straight ahead, her authority evaporating in real time. Before closing, the judge looked directly at me. He acknowledged that I had acted within my rights. That persistence and documentation, not aggression, had revealed the truth. That this case would serve as precedent. His final words echoed through the courtroom. Homeowner associations exist to manage communities, not to override ownership or law. The gavel came down. It wasn't loud. It didn't need to be. Outside, cameras waited. Neighbors who once avoided me now nodded. Some apologized quietly. Others said nothing, their expressions saying enough. As I walked away from the courthouse, I didn't feel victorious. I felt finished. They had taken trees that took decades to grow. The court had taken something they thought untouchable, their power. And this time, there would be no appeal that could grow it back. Months later, the land was quiet again. The machines were gone. The fencing came down. Where raised beds and gravel paths once stood, there was open soil, waiting. Environmental crews arrived, not to build, but to repair. Native saplings were planted in careful rows. Markers stood where old trees once rooted, each one a promise instead of a loss. The HOA board changed. Some members resigned. Others were removed. Meetings that once echoed with confidence now moved cautiously, guided by attorneys and oversight. The community farm existed only in memory and in court records. Neighbors started stopping by. Some apologized. Some admitted they never questioned the story they were told. A few helped water the new trees. No speeches. No celebrations. Just quiet understanding. As for me, I kept my records, my surveys, my proof, but I no longer needed to hold them so tightly. The land was mine again, not just on paper, but in practice. The woods will take years to return to what they were. But justice doesn't restore the past, it protects the future. They believed silence meant surrender. They believed power went unchallenged. All it took to prove them wrong was patience, truth, and the courage to let the law speak louder than anger.